Hi, I'm Carrie Felice, Probate Department Chair at Elder Needs Law. Paying real estate expenses after the death of a loved one. If you have a loved one that has recently passed away, you may be worried about keeping up with the expenses related to maintaining any real property that they owned. If your loved one owned real property, especially if they owned property other than their homestead, it's very important to speak with a probate attorney and get the probate process started right away. The sooner you are appointed personal representative by the court, the better suited you are to manage and maintain your loved one's real property. Now, unless otherwise provided for in their will, your loved one's homestead property, their primary residence, will automatically descend according to Florida's Constitution and statutes. So as long as someone who would inherit the homestead as an operation of these laws is living in the homestead, the personal representative has no authority to maintain or preserve the homestead real property. However, if none of these automatic heirs are living in the homestead, the personal representative may, but is not required to, take possession of the homestead to preserve, insure, and protect the property for the heirs until the court makes the determination that it was homestead and that it does now belong to these particular heirs. It's that determination that legally establishes in the official records and in the chain of title that the homestead has legally transferred to these rightful heirs. Now, if the personal representative expends money on preserving, insuring, and protecting the homestead, they may file a claim of lien against the property to recoup this money. This lien can be satisfied by foreclosing on it, by offsetting it from other estate assets, or it can be paid off when the homestead is sold. The personal representative may not, however, unless the will says that they can, the personal representative has no authority to actually sell the homestead. Now, for non-homestead real property, the personal representative has a fiduciary duty to preserve all estate assets, including real property. Therefore, as the personal representative, you're going to want to continue to maintain property insurance on any real property. This is the same for property taxes, particularly if the property taxes are already delinquent and the property is in danger of being sold at a tax deed auction. As PR, you'll want to keep the taxes, if not current, at least current enough that the property is not lost to a tax deed sale. If the property is expected to sit for any length of time, here in Florida, chances are you're probably going to want to keep the electricity service to the house, because without air conditioning, the Florida humidity can really damage property after a while. Also, if you're going to be selling the property, either the will directs that the property be sold, or you're selling it to split the assets between the beneficiaries. Your listing agent is probably going to want the electricity on anyway for real estate showings and inspections and things like that. Any of these expenses that the PR has to pay to preserve these real property assets can be either paid from or reimbursed from the estate assets. Just make sure you're keeping all the receipts for these type of things, and because they'll have to be reported on the estate inventory, the final accounting, and the distribution plan. All of those are things that will be filed with the court and provided to the beneficiaries, and they will have an opportunity to object to anything that doesn't look acceptable to them. So that's very important to keep all those receipts. So if you've recently lost a loved one and you need help initiating the probate process so that you can maintain and preserve their real property, please call us today, schedule a probate consultation. We'd be happy to help you.